State your name, sir.
Mr. Fox, before the court trial, possession of paraphernalia and a no valid driver's license. You understand the charges?
You understand what you're charged with?
No? No. He doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is. Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. I mean, this county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth about it?
It's not easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the contract.
Nobody's asking you to admit to anything. I just need to make sure you understand the charge.
Before we even hear the first charge read aloud, you can already feel where this is going. This is one of those courtroom moments where procedure meets personality, and the sparks fly immediately. Today's video features multiple defendants who believe that saying the right words or refusing to say anything at all somehow places them above the law. Spoiler alert, it doesn't. We're dealing with drug charges, license violations, bond issues, and a recurring theme you'll hear again and again: sovereign citizen logic colliding headfirst with real-world consequences. Watch how judges stay calm, direct, and laser-focused while defendants try to derail proceedings with word games, pseudo-legal theories, and endless...
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time. All right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on. What am I doing here?
Well, right now you are not responding to my questions. So
well, you're not responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first.
This exchange is a perfect example of how misunderstandings, real or intentional, slow everything down. The judge isn't asking for an admission of guilt, and that's a critical distinction many defendants pretend not to grasp. Arraignment is about awareness, not confession. Yet we see the familiar pattern, repeating the word allegedly as if it magically neutralizes a charge. It doesn't. Courts use precise language for a reason, and understanding the charge simply means you know what the state is accusing you of. Notice the judge's tone here, firm but patient. He's giving multiple chances for a yes or no response, and each time, the defendant pivots instead of answering.
Good morning, Judge Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
I was making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements. You're talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything, and you keep doing all of your little negative comments, things that you want to say about people. And you think you're the smartest person in the room, and that you have some sort of special Juris Doctorate, I guess, from somewhere.
There it is. The moment every courtroom viewer recognizes instantly, the phrase sovereign citizen changes the entire energy of the room. Judges know exactly what's coming next. Refusal to acknowledge authority, selective understanding of law, and endless philosophical detours. What's interesting here is the judge's reaction. There's no shock, no anger, just familiarity. He's seen this before, many times. Sovereign citizen arguments often rely on buzzwords, not legal precedent. And courts don't entertain theories that exist only on the internet. The judge's humor masks a serious reality. Once someone announces this belief system, they usually make their own situation worse.
You want another court-appointed attorney, so you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another pointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did well. I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date.
This judge's style is exactly why clips like this go viral. He blends authority with sharp wit, and that combination is devastating against courtroom theatrics. Humor here isn't disrespect, it's control. By keeping things light while staying legally precise, the judge prevents the defendant from hijacking the proceeding. And notice something important. The rulings are clear, the bond amounts are set, and consequences are explained plainly. No legal riddles, no ambiguity. This is what effective courtroom management looks like. Judges who allow endless back and forth lose momentum. But here, the pace stays tight. Every sarcastic remark still lands within a firm legal framework.
And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay, and same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof, and in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
This is a textbook example of consent myths crashing into reality. Many defendants believe saying, "I don't consent," is a legal shield. It isn't. Courts don't operate on personal agreement. They operate on jurisdiction and authority. The judge doesn't argue philosophy here. He simply states the requirement and moves on. And that's powerful. The more someone insists on debating existence, free will, or consent, the more detached they appear from the actual legal issue. The law doesn't pause because someone refuses to acknowledge it. That's why this hearing ends quickly. The court doesn't need permission to proceed.
What made you think they were expired? The wrong color and the wrong year on the plate itself, or some other thing?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you have to have insurance. Something regarding the Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you
that
tell
is
me a
in,
little bit more about the case? What was at issue in the case?
it was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating commerce, to which I informed the officer that I am not operating commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6.
This moment is where patience officially expires. Judge Slavin draws a hard line, and for good reason. Courtrooms are not debate clubs, and they're certainly not stages for personal attacks on attorneys doing their jobs. Notice how the judge reframes the issue. It's not about intelligence or imaginary legal credentials. It's about behavior. Disrespect toward officers of the court has real consequences. And when the judge mentions contempt, that's not hyperbole. That's a warning. Sovereign-style arguments often collapse once a judge refuses to indulge them. And here, the strategy backfires spectacularly.
Doesn't happen to be legally correct, but go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
But
well, I see what
I've heard your argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel
encumbered
and
now,
unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
This commentary hits harder because it cuts through the ideology. This isn't about labels or legal theories anymore. It's about behavior that affects real people. Courts don't just enforce statutes. They protect victims and maintain order. When someone believes court orders don't apply to them, that's when the system responds decisively. The judge's calm firmness here sends a clear message. Personal beliefs do not override protective orders or family safety. This is where sovereign arguments completely fall apart, because the law prioritizes harm prevention over philosophical objections. And when someone repeatedly ignores a reality, incarceration becomes not punishment, but necessity.
Or an Uber, or a plane, or a train, or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So,
okay, so
that is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
U.S. 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it says...
Hold
no
on. US
license.
147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, second edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case and what issue was before the Supreme Court in that case?
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't tell me what, that's not a complete cite of the case.
All right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
there are documents that have been scanned into the court that you dropped off.
traffic infractions are not crimes, blah blah blah. Person faced with
Right. Traffic infractions are not crimes. That's absolutely correct. They are civil infractions for a reason.
I was reading from a different case, but the case that I'm citing from states that no license necessary to drive an automobile on public highways, streets. No license is necessary. The word operator should not include any person who solely transport his own property and who transport no persons or property for hire or
where's that citation from?
Okay, I just appeal it, and that way I can make sure all citations are.
That's fine. I mean, the idea is I can't look up what you're telling me, right, without a proper citation. So you can read. I mean, for all I know, and I don't mean this, I'm using a farcical example. For all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no jurisdiction over Michigan.
It's
right?
understandable.
I don't know.
So I would cite Payne v. Massey, 19196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else you want to present to me?
If you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like you said, I have a right to appeal it. So
yeah, and I'm willing to listen. If you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise people could just run around quoting Mickey Mouse if they wanted.
Right. Okay. So
nothing against you. So the question to you is...
What we saw across these courtrooms was a consistent pattern. Defendants trying to outmaneuver the legal system with words instead of understanding it. Every judge handled these situations differently, some with humor, some with stern warnings. But the outcome was always the same. The law doesn't negotiate with misinformation. Whether it's refusing to answer simple questions, denying jurisdiction, or attacking court-appointed attorneys, these tactics never work. Judges focus on facts, procedure, and public safety, not internet theories.